All rise. Vous vous levez. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Bonjour.
Judge Kovacs, good morning.
Je souhaite la bienvenue à
I'd like to welcome everyone today here in the courtroom, as well as those who are in the public gallery. Courtroom officer, could you kindly call the case?
Good morning, Mr. President, Your Honors. The situation in the Republic of Mali in the case of the prosecutor versus Al-Hasan, Abdul Aziz, Mohammed, Mahmoud, case reference ICC 0112-0118. And for the record, we are in open session.
Je vous remercie.
Judge Kovacs, thank you. On behalf of my fellow judges, I'd like to welcome all parties and participants, and I welcome Mr. Al-Hasan as well. First of all, I'd like to ask if there have been any changes to the respective teams. Mr. Duterte. Mr. Duterte. Good morning, Mr. President, Your Honors. Today, my team is made up of Diane Looping, Isham Murad, Raymond Sandoval, Marie-Jeanne Saldacci, Sandra Flori-Houk, and Sarah Coquillo, and your humble servant. Thank you. The presiding judge, thank you. Defense, Ms. Taylor.
Good morning, Mr. President, Your Honours. Good morning, everyone in the courtroom. Today, the defense for Mr. Al-Hasan is represented by Madame Marilyn Prou, Mr. Monia Douce, Mr. Mohamed Youssef, Ms. Dolly Chala, Ms. Lily Wang, and Ms. Manuel Delille. Thank you very much.
Merci beaucoup.
Presiding judge, thank you. Legal representatives of victims, Mr. Any changes? LRV, no changes, thank you. The presiding judge, thank you. Judging by our schedule, we will now move to final remarks by the OTP, the defense, and LRV. I would like to remind you that according to the order setting out the schedule for the hearings, each party has 30 minutes for making their final arguments. I'd like to now call upon the prosecutor to address the court for his final remarks. Please go ahead, sir. Mr. Duterte. Mr. President, Your Honors, the Commissioner of the Islamic Police, Mr. Al-Hasan, played a key role in the implementation of the Common Plan. By making this statement, the prosecution is not trying to lay it on thick. I have said this right since the very beginning of the confirmation of charges. Al-Hasan is not Abu Zaid, nor is he Iyad Ag-Khali, but they needed him. They needed Al-Hasan to implement the common plan. The fact that the defense is trying to downplay the role played by Al-Hasan, no, that won't do. Mr. Al-Hasan was the central figure within the Islamic police, one of the main bodies that was imposing power and implying an ideological and religious vision of Ansar Dine and ACME in Timbuktu. I have only 30 minutes. I will have to speak quickly, even though I have 10 points to cover, because the defense has made a number of erroneous and misleading remarks. First of all, Al-Hasan is a member of Ansar Dine. You won't necessarily find a membership card with his name, but the evidence shows that he was a member of this armed group. Al-Hasan said so himself. I quote from his interview, MLI OTP 00510513. Excessive speed. Excessive speed. I will be referring to both the interpreter and to the interviewer. I will begin the quote. Interviewer. You yourself joined the police, but were you member of a group? Interpreter. Before the police? Interviewer. No, not before the police. When you were with them in Timbuktu. Interpreter. The fact that I joined the police, it was with Ansar Dine. End of quote. Transcript 0051, 1067. Al-Hasan described a meeting with Tuareg leaders in Timbuktu, lines 217 to 218, during the occupation of Timbuktu. He said, and I quote, "It was a few days, not even a month after, I joined their ranks," end of quote. Second point, Mr. President, Your Honors. Al-Hasan is not a civilian. There are multiple items that prove this point, but I have two examples for you. First of all, video 0065, reference numbers read out at very high speed. This has to do with a person in Timbuktu in June 2012. In the transcript, Al-Hasan acknowledged that he was present as a police officer. The presiding judge, please slow down, Mr. Duterte. Mr. Duterte, it's always a difficult balancing act. Mr. Duterte, lines 9 to 51, Al-Hasan made some comments on the first video, 0018, 0658. He can be seen on the footage. He confirms that he was wearing a vest of the Islamic police, a yellow turban, and a sari-colored shirt. On the second video, 0018, 0649, timestamp 1015, we see Al-Hasan once again. He was still wearing the same clothing, and he also had a weapon slung around his shoulder, over his shoulder. Second example, Al-Hasan continued military activities with Ansar Dine and ACMI after the occupation of Timbuktu. In his interview, he stated, transcript 0060-1791, lines 562 to 563, and I quote, I helped people who killed the United Nations, who killed the French, who killed the Malian army, end of quote. Transcript 0051, 1067, line 368. Al-Hasan stated, and once again I quote, I was the person responsible for a military base, end of quote. Third point, Your Honors, Al-Hasan was the de facto commissioner of the Islamic police, not an administrator. He was the one who received complaints from people who came to see him. They would see him in his office. He conducted investigations, questioned people, drafted investigation reports, and he was the only one to sign such reports. He sent these reports to the tribunal, and the investigation reports were the main source for the various rulings handed down by the Islamic Tribunal and the punishments meted out. You also saw Al-Hasan himself lashing people in the public square or taking part in public punishment of people. As for the second case, 29 November, Al-Hasan drafted a police report. The tribunal based itself on this report to find the person guilty, and Al-Hasan himself flogged at least one man. Furthermore, Al-Hasan brought this person out of the police officer who had been condemned to death, to take him to the place where he was going to be executed. Transcript 0060-1327, lines 60 and 61. These sort of duties are not the duties of an administrator or a pencil pusher, but rather they are the duties of a police commissioner carrying out the duties that had been allocated to him. I will leave it at that, because there are many examples. To tell you the truth, Al-Hasan was indeed the zealous commissioner and a member of Ansar Din. It's not important whether he was an official member of the armed groups or whether or not he pledged allegiance to these groups. What is important here is what he actually did, his actions. Fourth point, Your Honors, the degree to which the Islamic police contributed to the repression of the general population, which was a very high degree of participation. First of all, the police is obviously an important body within society. The dates and the places prove this. The police was one of the first bodies established in April 2012. First of all, the police set up operations in the BMS, one of the few multi-storied buildings in Timbuktu. Then the police moved to the Gouvernorat, which was, by definition, the most important government building. This tells us a lot. Secondly, you shall recall that the Islamic police were engaged in a broad range of activities. Al-Hasan himself gave an illustration of this in video 00160379. He said, and I quote, and it's in English,
"We do have a lot of work. It involves patrols within the town and correcting objectionable acts, any type of reprehensible which has been forbidden. We correct such acts as drinking alcohol, smoking, and a woman adorning herself, and other such acts. It involves running the town affairs and ensuring the whole town's security day and night." Fermez les guillemets.
End of quote. In actual fact, the police were everywhere in Timbuktu. They dealt with everything that was going on in the city. They issued various permits for a number of activities. They summoned people. They received complaints. They dealt with various cases that were problematic, cases of adultery, practicing magic, theft, dealing in cigarettes, selling alcohol. Third point, the police who were in charge of the prison, and I refer to MLI OTP 0051-1124, line 801. The police worked with other bodies, in particular the Hezbollah and the Islamic police. These other authorities could not carry out their missions without the assistance and support provided by the Islamic police. Any new combatant had to report to the Islamic police with his papers. Fourth point, the instructions of Abu Zaid, and I will quote these instructions.
To the police, its backups, and all soldiers. Fermez les guillemets.
End of quote. I refer you to 0001 7193. My fifth point. We know that the police had more men amongst their ranks than the Hezbollah. I refer to the DCC. In numerical terms, they had the human resources, more human resources, to take action against the people. Similarly, they had more physical resources. Remember the pickup truck patrolling with the two armed police officers? They were patrolling in cars or on motorcycles. Al-Hasan said this, "There's no problem. We have access to weapons. The people are all armed." Reference 0018-0379. My sixth point, and this is quite revealing, the police officers were quite often visible on the video footage shot at the time in Timbuktu. They could be seen in the street or at the Islamic Tribunal. My seventh point, they were part of all actions to repress the people. We know that it was the Islamic police, and in particular Al-Hasan, who provided cases to the tribunal, that is to say, future victims of punishment and public humiliation. The police was also part of all the punishments given and all the repression, the whipping of June 2012, the amputation, and so on and so forth. The police also had a role to play in maintaining control and power over groups outside of Timbuktu. In the interview dated November 2012, Al-Hasan spoke of missionary expeditions from Timbuktu into the northern territories of Mali, 0018-0379. In fact, the police officers would travel hundreds of kilometers on these missions as far as Léré. This is all I have to say about my fourth point. I'd now like to move on to my fifth point, and I shall now switch to English.
Fifth point, the common plan and mens rea. I now turn to the arguments raised by defense about the common plan and the relevant test of mens rea. I refer to defense submissions at transcript 6, English, page 32 to page 33. The defense is confusing the nexus requirement concerning the armed conflict and commission of rape and sexual slavery with the scope of the common plan. Defense further mischaracterizes the prosecution's arguments concerning the definition of the common plan and test of intent and knowledge under Article 30. First, the nexus requirement for an armed conflict and the issue of the scope of a common plan are two entirely different legal questions and should not be conflated. Evidence that crimes had a nexus to the armed conflict does not necessarily depend on proof that they were committed according to a common plan. Second, by saying that the commission of crimes of rape and sexual slavery were foreseeable, this simply means that Mr. Al-Hasan was aware that such crime would occur in the ordinary course of events, which is the relevant test using the plain language of Article 30, subparagraph 2b, as well as under Article 30, subparagraph 3. Contrary to the defense claims, at no point did we say that the Chamber should adopt the standard of joint criminal enterprise number 3, which is awareness of substantial likelihood that the act will occur. Third, the defense analogy to a peacekeeping mission is totally unfounded. As in this case, we say that the suspect both knew and intended the charged crimes, as he was at least aware that they would occur in the ordinary course of events in the execution of a common plan. Fourth, I wish to clarify the prosecution's case as to the scope of the common plan. The plan was, inter alia, to impose their own ideological and religious vision by any means. The charged crimes, including rape and sexual slavery, were consequences that Al-Hasan was at least aware would occur in the ordinary course of events as a result of implementing this common plan. In this way, we must prove that the crimes occurred within the framework of the common plan because the co-perpetrators were aware that the crimes would occur as a result of implementing that plan. But we do not have to prove, and our case is not, that the crimes were necessarily seen as part of the plan itself. I now turn to my sixth point. The contribution for Article 25, subparagraph 3a. I next respond to three issues raised by the defense concerning contributions to be proven under Article 25, subparagraph 3a. First issue. I refer to the defense attempts to distinguish the appeals chamber judgment in the Bemba Article 70 case. In the defense submissions at transcript T6, page 36 to page 37, the defense tried to argue that the Bemba Article 70 appeals judgment regarding the common plan theory does not apply in this case because Bemba was the architect of the common plan, whilst Al-Hasan was not. But the defense misinterprets the decision and the law on contribution for Article 25, subparagraph 3a. At transcript T6, page 37, the defense also tries to limit the application of the appeals chamber test as to whether, but for the suspect's essential contributions, the crime would not have occurred, or alternatively, it would have occurred in a significantly different way. The defense argues that this alternative test, that the crime would have occurred in a significantly different way, only relates to Article 70 offenses and not Article 5 cases. The defense, Your Honors, is attempting to turn evidentiary considerations into propositions of law, which is incorrect. The legal principle stressed by the appeals chamber was that, for the purpose of Article 25.3a, a person may make an essential contribution as a co-perpetrator within the framework of a common plan if their contribution was such that, without it, the crime could not have been committed, or they would have been committed in a significantly different way. I refer to D1 of the reference list we dispatched this morning. This reasoning applies to Article 25.3a in general. It is not specific to Article 70 rather than Article 5 crimes. There is only one Article 25 provision, and it must be interpreted the same way regardless of a crime. Whilst the appeals chamber agreed with the trial chambers, finding that Mr. Bemba made his contribution by means including being the architect of a common plan, it was not making any legal finding that this is the only valid form of an essential contribution. ICC jurisprudence clearly indicates the contrary. Indeed, the appeals chamber in the same Bemba case confirmed that essential contributions to implementation of a common plan can be made in many different ways and need not even be criminal in and of themselves. I refer to D2 of the reference list. This demonstrates that a person may make an essential contribution for the purpose of Article 25.3a without necessarily directly perpetrating one or more crimes themselves. Moreover, the ICC jurisprudence also makes it clear that the essential contributions to a plan can be made at any stage, including at execution stage of a crime, the planning and perpetration stage, as well as the stage when the common plan was conceived. I refer to D3. Second issue regarding the common plan. The defense has argued that the charged crimes, in this case, would have happened in substantially the same manner, irrespective of whether Mr. Al-Hasan was in Timbuktu or not. Transcript T6, page 37 to page 38. That is incorrect, Your Honors. The question is not what would have been the impact on the crimes if Mr. Al-Hasan, as an individual, was present or not in Timbuktu. The question is whether the crimes would, for instance, have happened in a significantly the same way if Mr. Al-Hasan did not make his essential contribution to the plan that he made in the role and functions he exercised within the Islamic police. And we say that if you removed his personal conduct as de facto commissaire of the Islamic police, the crimes indeed would have occurred in a significantly different manner. For instance, there would not have been the same coordination for the police, or its work with the other organs, including the tribunal, to whom cases were referred by him, and the SBA, who received support from the police during patrols. In addition, tellingly, Al-Hasan was maintained at his key position throughout the occupation. He was indispensable at the police, receiving complaints, investigating and drafting reports, using his power, influence, and language skills in dealing with the population. Third issue regarding the common plan. The prosecution refers to the defense arguments at T6, page 26, that if one of his essential contributions were as a key enforcer or implementer of the organization's rules, this means we must prove that Al-Hasan had a role in implementing the charged crimes. At transcript T6, page 36 to page 37, the defense similarly argues that we must prove that Al-Hasan executed or contributed to the realization of the charged crimes. This again, Your Honors, misstates both the prosecution's case and the law as regards essential contributions under Article 25, subparagraph 3a. There is no requirement to prove that Al-Hasan, as a co-perpetrator, implemented the crimes, executed or contributed to their realizations. The appeals chamber has confirmed that it is not necessary to prove that a co-perpetrator made an intentional contribution to each of the specific crimes or offenses on the basis of a common plan. I refer to D4. The requirement is to prove an essential contribution to implementing the common plan, which means that the suspect is then liable for the crimes that occur within the framework of that common plan. I refer to D5. In fact, other than the mode of liability of direct perpetration of crime under 25 subparagraph 3a, none of the mode of liabilities as charged require proof that Al-Hasan made any direct contribution to the crimes. Whilst Article 25 subparagraph 3d does require evidence that he otherwise contributed to the crimes, this can be indirect and not direct contributions. For example, by encouraging crimes tacitly or explicitly.
Monsieur Duterte, les derniers.
Judge Kovac, Mr. Duterte, you have 5 last minutes. Mr. Duterte, thank you, Your Honor.
Seventh point, principle of legality. Defense argues that illustrative references to the content of certain law, including the laws of occupation when interpreting Article 8(2)(c)(4), offends Article 22. However, as the appeals chamber has demonstrated on multiple occasions, interpreting the law of a statute does not contravene the principle of legality. Moreover, even though the laws of occupation relate to the different context of an international armed conflict, it is appropriate to refer to these laws to understand the full meaning of Article 8(2)(c)(4), bearing in mind the references to Common Article 3 of the Geneva Convention. That's reference A12 in the reference list. We will address that in more details in our written submissions. Eighth point, Your Honors. Notice of scope of the charges. Contrary to the defense arguments, the prosecution has not tried to expand the scope of the charges, in particular the material facts and circumstances underlying the charges. Every example during the confirmation hearing amounts to either evidence or even legal arguments in support of the charges. But none of the examples provided by the defense are material facts or circumstances underlying the charges. Defense mentioned the phone numbers, it's just evidence. Defense mentioned the legal summation under Article 8(2)(c)(4). By definition, legal summations are not material facts. Neuvième point.
Ninth point, Mr. President, and I will revert to French. Mr. President, Your Honors, I will come back to the issue of the phone data, and I believe they are highly incriminating. Let us begin with the attribution of number 223792623992. That is the number on the signpost of the Islamic police. The number 223 is the country code for Mali, and the digit 7 appears to be the code of the operator. Then you have the phone number itself, 9262392. This number appears on the signboard of the Islamic police at the BMS. The defense states that the prosecutor attributes that number without any reason to Mr. Hassan. Let us be clear, this is simply misleading. Let me come back to the transcription of the interview of Mr. Al-Hasan, MLI-OTP-0060-1403 from line 260 onwards. And I quote, interviewer, you do remember that you spoke to us about the telephone numbers of the police. Interpreter, yes. Interviewer, and you in fact said that the numbers were posted under the inscription of the police on the signboard. Interpreter, that is correct. Interviewer, you gave the figures 926. Is that correct? Interpreter, that is correct. End of quote. And now I move to line 282. Judge Kovac, how much time do you have left? Mr. Duterte, I am concluding. Interviewer, very well. Number 926, this is my number. I bought that number well before the arrival of the Islamists in Timbuktu. And for all the other numbers, amongst all the other numbers, we have this number for Mr. Al-Hasan, who had it before the arrival of the jihadists. And as he himself said, this number became the number of the police on line 419. This is his number, which he used with other people. And for each number, we had sources that were disclosed as incriminating evidence. In the final analysis, Mr. President, Your Honors, the prosecution submits that all the facts, and you have to base yourself on the facts, all the facts and nothing but the facts. These facts show that there are substantial grounds to believe that Mr. Al-Hasan perpetrated the crimes charged against him. That is why I am asking you to confirm the charges. Thank you. Judge Kovacs. Thank you, Mr. Prosecutor. We will now move on to the presentation of the legal representatives of victims. Mr. Dumbia, please, you have the floor. Mr. President, it is Maitre Mayombo who will begin. Thank you. Judge Kovacs, very well. Maitre Mayombo. Thank you, Mr. President. Your Honors, I am Maitre Kasongo, the legal representative of the victims of Timbuktu. I will be very brief and concise in order to allow my colleague, Maitre Dumbia, to conclude. My entire presentation is public, and I would like to talk about 3 points in my closing observations so as to shed light on the confirmation of charges proceedings. These 3 small points derive from the response to the observations made by the defense. To begin with, I would like to let it be known to the chamber that the arguments submitted by the defense in relation to the person of Mr. Al-Hasan and to Sharia as being applicable in Mali at one point cannot be admissible. Secondly, I would like to underscore the diversion to a religious debate, which itself is not admissible. Mr. President, the prosecutor did not base its charges on Sharia and the religion. The intervention of Marie-Hélène Roux elaborated in her arguments their observations. To begin with, the defense talks about the conduct and personality of Mr. Al-Hasan as a good family man and father, and this was made on the 11th of July, and this is lines 10 to 25, page 13. Mr. President, Your Honors, on the issue of a good family head, the victims refuse to believe the presentation of the defense describing Mr. Al-Hasan as a good family head, because this is a single example amongst the 800 victims, and from their point of view, Mr. Al-Hasan is not a good family man. They were victims, barely 10 years old, pursued in the streets for not wearing a veil. They arrived in the commissariat at the bidding of Mr. Al-Hasan. They were gang raped in an atrocious manner, and these children remained in the police station while Mr. Al-Hasan was there supervising. It cannot be said that he is a good family man. He would have been so if the father of this girl who witnessed the events had not died after that. Mr. President, you have the conduct of a good family head if the author of the act was able to demonstrate that he was vigilant and concerned by the criminal acts taking place in his presence. That was not the case with Mr. Al-Hasan. International jurisprudence tells us that the person who can discern the difference between crimes committed by a group and he himself tried to prevent those crimes can be considered as a good family head. That is not the case with Mr. Al-Hasan. The war in 2012 was the origin of the crimes perpetrated upon the victims that we represent. It is the most important cause of the acts of torture committed in the presence of Mr. Al-Hasan. The other point that struck us was the argument to the effect that Mr. Al-Hasan is a Tuareg. Mr. President, the victims do not believe for a minute on the stigma of the Tuaregs. No. Mr. Al-Hasan did not commit the crimes through justifying the stigma on the Tuaregs. And we have shown that and will show that in our written submissions. This is an issue that is linked more to dogma and literature. Just to summarize, in the earliest literature, you had veiled people. And this is an issue that has been well elaborated upon and documented. I will move on and allow my learned colleague to come back to that. But Tuareg comes from the word Taurik and Tardu in the colonial literature. It is a literary distortion which has no meaning. My colleague will come back to this issue and we will demonstrate it to you in writing. Your Honors, when the victims hear from the defense the reference made to Sharia as the applicable law, there is a need to respond. I will seize this opportunity at this point of the proceedings without dwelling at length on the principles. I would say, Mr. President, that in their submissions of the 11th, there was a demonstration on the fact that the prosecution did not focus on the rights, on that law and the legality of the law. All the mass of victims that we represent, Mr. President, believe that that argument cannot prosper. They cannot be used to justify the crimes charged against Mr. Hassan. Article 15 of the statute gives the right to the prosecutor to select the charges and present them. Through our voice, the victims would like to reject the defense argument founded on the application of Sharia in Mali before the occupation in 2012, and the victims respectfully request the chamber to declare those arguments null and void. Mr. President, Your Honors, the core of this case of confirmation of charges is to describe the elements of the charges. The victims would like to participate in a serious manner, so it is not appropriate to open a religious argument and talk about religious-based arguments which will go against the interests of the victims. The town of Timbuktu is mainly inhabited by Muslims. From what we have learned in the doctrine from various authors, we are going to include in our written submissions. There is a body of legal rules which include limits, and the contemporary debate has focused on that, particularly in the West, with regard to Sharia. These are principles and customs that play a complementary role in addition to the Quran. The contents are not detailed. There are prohibitions, but the punishments are not specified. You have schools of thought to say that this is not consistent or unified law. Mr. President, there are various schools of thought. Mali is a secular state, and even though it has Muslims, Mali does not apply Islamic law as such. All the Muslims are under the jurisdiction of a system which applies tolerant Islam. Mali remains a secular state. Mr. President, Your Honors, Timbuktu was founded in the 11th century by the Tuaregs, who entrusted their heavy burdens to a woman, and that is how Timbuktu became Timbuktu. We are far from the issues raised by the defense. Timbuktu was reputed for the presence of highly respected intellectuals. There was no problem of stigma of the Tuaregs. People talk about the Quran and Islamization through the Sultan of Morocco. And then you had the battle of the intellectuals. I will conclude, Mr. President. Based on those hypotheses, the victims would like to respectfully request the chamber to dismiss all the arguments of the defense, which are based on ethnicity, and the chamber should confirm all the charges made by the prosecution. Mr. Kovac, thank you very much, Maitre Kasongo. Mr. Dumbia, now you have the floor.
Merci beaucoup, Monsieur le Président. Honorable.
Thank you very much, Your Honors. I would like to discuss 4 points primarily, and specifically I'll be speaking to our hesitations about this case, our assessment of the evidence against Mr. Al-Hasan, our perception of Mr. Al-Hasan's personality, and our judgment of the arguments presented by the defense, and then finally a few concluding remarks. Now, on the first point, Your Honors, once again, I reiterate that we are very satisfied to be here. We are happy to have time to address the court, and we are very comforted by this because this truly shows that the victims have a role here and that the legal representatives of victims play a role here at this court. Mr. President, we intend to fulfill our role entirely in accordance with your directives, in particular in relation to the questions that you have submitted to us. We plan to make written filings in response to these questions with greater detail. Mr. President, Your Honors, if I could turn to the evidence that has been brought before this bench by the prosecution, the legal representatives of victims are of the view that this evidence is sufficient. The prosecution, in our view, has provided more than enough evidence that would allow you to confirm the charges. The evidence is clear, and it falls very much within, it is aligned, so to speak, with our objectives. And the evidence is in accordance with the horrors that the victims whom we represent have experienced. Mr. President, Your Honors, the prosecution's request must be seen favorably, and the charges must be confirmed. Both in terms of content and substance, the prosecution's arguments are there. And we have to acknowledge a number of things we cannot deny. And there is no person blinder than the person who does not want to see. And there is no one more deaf than the person who wishes not to hear. We must have objectivity here at this court. Now, Mr. President, Your Honors, the legal representatives of victims wish to state before this court that the arguments presented by the defense just don't hold water. And we see this in a number of statements. For example, this statement made, page 37, transcript of 11 July 2011, lines 22 and 23. The defense said, you can't infer criminality from non-criminal conduct. Well, this conclusion is the final point in a rather truncated line of reasoning. It is the final point of a legal fiction, a certain view that just does not bear up when one looks to the evidence. This argument makes no change to the evidence that has been brought before the court. When it comes to the Tuareg issue, the defense has attempted to how should I put this, evade the issue. The defense has tried to throw up a smokescreen telling you that the Tuareg people lived in difficult circumstances, and this explains to a large extent why the uprising occurred. Your Honors, what I am telling you, and this is the truth, is that Mali, ever since the independence up until right now, Mali has never given more than, well, even a fraction of the budget to the budget that in comparison to the proportion of the budget allocated to developing the North and assisting the Tuareg. This has been shown, Mr. President. This point leads me to another issue, namely the personality of Mr. Al-Hasan. Mr. President, Your Honors, the victims whom we represent here before this court will tell you, correction, will never tell you that Al-Hasan is a good man, a man who did good for his community, a man who was loved by his community. No, they shall never say such a thing. They will tell you, in contrast, that this man is no angel, and this is true. He is no angel. Al-Hasan is far from this good family man depicted by the defense, this image that the defense wants to sell to you. This is absolutely false. Your Honors, the victims of Timbuktu, who suffered greatly under Al-Hasan, who suffered in their flesh, who shed blood, who shed tears, who... These victims will tell you that they saw Al-Hasan. They saw him do his work. They saw how cynical a man he was. Al-Hasan was not loved within his community, in contrast to what the defense said, page 16, lines 22 to 28 of the transcript of 11 July 2019. Or at page 16, lines 9 to 11 of that same transcript. The victims will tell you that Al-Hasan was constant, unwavering in his behavior. And what do I mean by that? And Al-Hasan himself recognized this point. Threats and torture were amongst the methods used during the investigations that he led. And he said torture was just a matter of hitting the person, as if striking a person was not significant. And this is clearly seen in the transcript of 11 July 2019, page 19, lines 9 to 12. Another thing that never changed, that was constant, was that Mr. Al-Hasan never denied that he was the head of the police, of the Islamic police in Timbuktu during the occupation. It was also a constant, well, it was, how should I say this? Al-Hasan had never denied that he himself conducted floggings. We have seen the footage. This was an initiative of the decision, but he also was the person who carried out the actual act. So we see a certain constancy, a certain steadfastness. Al-Hasan knows this. He played a key role. he was a full-fledged part of the jihadist system in Timbuktu. This is clear for all to see. I shall now move on to the defense's arguments. The defense has based its arguments on elements that are not fair, not equitable, not objective, not true. On this side of the courtroom, I can say that we are shocked and indignant when we hear the defense say that the evidence can be summed up as a handful of incidents. Mr. President, the events, what actually happened, what happened to our victims were not just incidents, and we cannot allow these events to be dismissed as mere incidents. They were crimes. They were serious violations of the standards of international law that are to be found in the Rome Statute. And this is why we are all here today. One cannot merely dismiss what happened as incidents. Mr. President, one can present a defense, but remain within certain boundaries. This is what we are asking for. Mr. President, Your Honors, the legal representatives of victims think that the video footage and the maps and the photographs and the witness statements and all the allegations are directly linked, have a clear link not only to these proceedings, but also to the behavior of Mr. Al-Hasan and everything we have been discussing here in this courtroom. Mr. President, here, if we look beyond the fact that Mr. Al-Hasan acknowledged that he personally carried out the actions for which he has been charged, if we look beyond that, we see as well that the people who were victims in Timbuktu will tell you that Al-Hasan played a determining role. If he had not been there, the crimes would not have been committed in Timbuktu. The victims will tell you that not only did they see Al-Hasan order and take part in the torture ordered. Mr. President, Your Honors, these are facts, and facts are stubborn creatures. Al-Hasan could not have done this without being in a position of authority. And this proves the important role that he played within the community and how he was an important part of the commission of the crimes. We concede that the defense has to play the devil's advocate. They are entitled to, but the court should not be deceived, and we are confident the court will not be deceived. We are confident you shall not be misled. I think it's essential to recall, and the legal representatives of victims intend to speak on behalf of the victims, to echo what they have said, to be their voices. And I'm making reference to the principle of equality. And that the arguments of the defense based solely upon legalities cannot succeed. This trial is not a trial of Islamic law. It is not Islamic law that is on trial here. Sharia is not on trial here as a legal system. No, this is the trial of a man who committed serious crimes and must be held accountable for them. Thus, the defense should not attempt to deceive, because you see, the Sharia is a word that means a group of standards taken together, standards or norms that regulate society within the Islamic world. My colleague, Mr. Mayambo, said very well that Mali is not an Islamic country. Even if one might understand that in Timbuktu, life is governed by standards that come from the Islamic tradition, that it does not mean, that cannot mean that Sharia was being applied in Timbuktu. That is just not so. In Timbuktu and elsewhere in Mali, there is one system of law that prevails, and that is a system of law that comes from the Roman Germanic tradition. It is a remnant of the colonial past of Mali, and it is the only legal system in force in Mali. What does this mean? Well, this means that the habits, the customs, and so on and so forth in Timbuktu, which stem from the Islamic tradition, were not contrary to public order in Mali. That cannot be used to justify the statement that Sharia, the presiding judge, you have 3 minutes. Thank you. I assure you I will conclude within the time allocated to me. Just to make one point relating to language. In Mali, in most languages, the word loi, law, is translated by Sharia. And that is a very important point of language. When a Bambara person says law or the legal system, he will use the word Sharia. When he means that your comportment is wrong, he will say, the way you're behaving, that is not Sharia. And when someone says, when a witness says in Timbuktu that Sharia was enforced, that person merely means that in Timbuktu there already was a system of law. And that mustn't be confused with what the jihadists applied in Timbuktu, which was not an application of Sharia. That point must be made first and foremost. The jihad fighters acted only with a view to install terror within the Sahel in general terms. This was part of a geopolitical game. They wanted to seize power and do as they wished in the city of Timbuktu. I shall now conclude, Your Honors, and once again allow me to reiterate that the victims remain hopeful that you shall confirm all the charges and dismiss all the nonsense from the defense, and these victims remain hopeful that justice shall prevail. Thank you, counsel. We shall now conclude with final remarks from the defense. Ms. Taylor, in the 30 minutes you have, you'll have to allow some time for your client if he wishes to address the court directly. Thanks to the generosity of the interpreters, we can continue until 15 minutes after 11. Please proceed, Ms. Taylor.
Thank you very much, Mr. President, Your Honours. After reading the prosecution's voluminous charges, after hearing from them over the course of several days, we are still left with the fundamental question: why are we here today in court with Mr. Al-Hasan in the dock? In July 2012, the Malian government listed the principal actors in the different movements in the north of Mali. There were 14 different names that they wanted the court to investigate. Mr. Al-Hasan was not one of them. That's MLI OTP 0001-0026. And in 2018, after investigating the events in Mali for several years, the prosecution submitted their own application for an urgent arrest warrant for Mr. Al-Hasan, and at paragraph 59, they listed the principal actors, the principal chiefs of the alleged oppression in Timbuktu. And they listed 4 names. Mr. Al-Hasan was not one of them. And in 2009, after investigating the case further, the prosecution filed the voluminous charges, and at section 7.2.2.2, they listed all of the persons who played the key roles and performed the essential tasks in Timbuktu. At paragraph 224, they described the presidency responsible for controlling daily life in Timbuktu, the persons who assisted and controlled the key organs used to implement the common plan. They named 3 persons. Mr. Al-Hasan was not one of them. The prosecution then listed the essential contributions to the common plan. So who was responsible for giving orders to the Islamic police? Who issued the written instructions to be followed by the Islamic police concerning their interactions with the public? Who had the power to intervene in judicial procedures? Was it Mr. Al-Hasan, the person here today? No. According to paragraph 245 of the prosecution's own charges, it was Abu Zaid. And in this case, which concerns the implementation of religious beliefs and practices, who was responsible for determining which aspects and practices of Islamic law should be followed in Timbuktu? Was it Mr. Al-Hasan, the person detained by the ICC for over 15 months? No. According to paragraph 247, it was Abdallah al-Chingeti. And after hearing days of arguments concerning the fact that women in Timbuktu were forced to wear the veil and conform to certain practices, was it Mr. Al-Hasan who decided on these moral rules, who enforced them? Not according to paragraph 248 of the charges. It was instead Al-Mahdi, who organized and controlled the punishments of civilians in Timbuktu, including the imposition of the clothing code. And Islamic court judgments, these decisions, which the prosecution has alleged violated the Rome Statute, did Mr. Al-Hasan write them? Did he issue them? Was he the one who issued or authorized the Hudud punishments or interrogation techniques, not according to the prosecution's charges. Paragraph 254 attributes that essential role to Huga Huga, the president of the Islamic Tribunal, a person who is a judge, not an individual who had no legal, police, or religious training. And when we come to the work of the Islamic police itself, who were the emirs? Who were in control, who issued the orders and were responsible for making the essential contributions to the common plan? According to the prosecution, it was Adama and Khalid Abu Sulaiman, and that's at paragraph 250 of the prosecution's charges. Mr. President, Your Honours, Mr. Al-Hasan is an accidental suspect, suspected of crimes that have no nexus to him or his daily conduct in Timbuktu. Common plan theory can only stretch so far, and in this case, this common plan for religious beliefs has been stretched beyond belief. The prosecution case lacks context, it lacks a viable common plan, it lacks criminal conducts, and it lacks credible evidence. And it should not, therefore, be confirmed. So, context. We have heard the chamber underline many times that the burden of proof falls squarely on the prosecution. The prosecution, not the defense, the prosecution must prove all material elements of their case. But they can't do that by simply ignoring inconvenient truths, presenting snippets and snapshots of the most extreme forms of conduct committed by the most extreme elements of Ansar Deen. Their charges have to be framed within the daily life and reality in Timbuktu at that time, and Mr. Al-Hasan's daily life and reality in Timbuktu at that time. But as my co-counsel, Ms. Prue, explained last Thursday, there are at least two key aspects that have been airbrushed out of the picture. And these are the situations of the Tuaregs in the north of Mali and the existence and role of Sharia law in Timbuktu. Last Thursday, Ms. Prue played the missing elements from the video, which the prosecution had used for their opening speech. And we heard that Timbuktu and its surrounding villages were the land that the government of Mali forgot, isolated from the state. And under this negligent and non-existent state stewardship, the Tuaregs in North Mali had the world's lowest quality of life. This context, this missing context is crucial. Tuaregs, such as Mr. Al-Hasan, didn't work with Ansar Deen because they were religious zealots. They worked with the Ansar Deen administration because it was all there was that was working. The state had left the building. Before Ansar Deen, there was no security, no order, no law, no fundamental services, and no real choices. The prosecution has relied on Mr. Al-Hasan's statement as their sole evidence concerning the circumstances in which he commenced working with Ansar Deen. But let's look at what the statement says. He didn't agree to interpret for the police because he wanted to do jihad. He was convinced to interpret, and he agreed because he hoped that he would be able to work at the hospital and get more experience. That's MLI-OTP-0051-1257 at 1286. And this Mr. President, Your Honours, this is Mr. Al-Hasan, a pharmacist from Timbuktu, not a foreign jihadist or terrorist. He didn't agree to work with Ansar Dine so he could oppress his fellow citizens or persecute them. The prosecution's own evidence says that he did so because, firstly, Ansar Dine pursued him and asked him to. And secondly, he thought he'd be able to use his skills to make life better for that people at that point who had the lowest quality of life on earth. So where is the mens rea? Where is the proof that Mr. Al-Hasan agreed to be part of a common plan to commit crimes against the people of Timbuktu, his own people? The second element, which is missing in action, concerns the nature and content of Sharia law and its relevance to the common plan. Last Wednesday, the prosecution made a declaration at page 71 of the transcripts that, contrary to what the defence has argued in their submissions, the prosecution is not stating that the criminal element of the common plan was about implementing Sharia law. Nor is this a case about prosecuting Mr. Al-Hasan for his religious beliefs. When we read the charges in this case, it's clear the prosecution might as well have claimed that this is not about a common plan to install Sharia law. It's about a plan which was common to install religious practices based on Sharia. Because no matter which way you frame it, the prosecution's common plan, as set out in their charges, requires the pretrial chamber to accept the implementation of Sharia law amounted to crimes against humanity and war crimes. And as a result, if the chamber accepts this formulation, it would mean that any state that practices Sharia law would expose the members of its administration to severe criminal penalties if they were to ratify the Rome Statute. And that's hardly a clarion call to universal ratification. And as my co-counsel, Ms. Prue, explained last week, in terms of context, Ansar Dine did not bring Sharia law to Timbuktu. Sharia law existed there before Ansar Dine and exists there today. And that was based on the prosecution's own evidence and their translations. So if it's the prosecution's case that certain aspects of Sharia law were new and inherently criminal, then the charges should specify very clearly which aspects were new and which aspects were inherently criminal, and who had control over those specific criminal aspects. But for a case which is so centered on Sharia law, the prosecution's allegations and arguments are surprisingly silent as concerns the structure of Sharia law. And why are they so silent? Because, Mr. President, Your Honours, Mr. Al-Hasan, a person with no legal, religious, or police training, had no power and capacity to interpret Sharia law. He had no power to influence the type of Sharia law punishments implemented in Timbuktu. These punishments, these hudud punishments, are prescribed by the Quran. Issues of interpretation are decided by the Qadis in consultation with the Judicial Council. These matters fall well outside the authority, well outside the sphere of influence of someone like Mr. Al-Hasan, who could be punished and physically disciplined by the Emir if he failed to follow orders. And I refer here to paragraph 372 of the prosecution's charges. If responsibility were to lie anywhere, Mr. President, Your Honours, it would rest with the individuals who decided to apply these particular aspects of Sharia law in Timbuktu. And according to the prosecution's own charges, that's not Mr. Al-Hasan. That moves me to my second point, the missing criminal conduct. The most important question before the pretrial chamber right now is not whether crimes were committed in Timbuktu, but whether the prosecution has presented sufficient evidence to establish that Mr. Al-Hasan, the person sitting in this courtroom today, is criminally responsible for these particular crimes. And on the basis of the evidence that was disclosed and discussed in court last week, we submit that the answer is a resounding no, and that as a result, Mr. Al-Hasan should be released immediately. This conclusion can be readily established by addressing the prosecution's core claims concerning Mr. Al-Hasan's individual responsibility. Because without individual responsibility, there can be no case. During last week's hearing, the prosecution expended a considerable amount of time arguing what they didn't have to prove, rather than what they'd actually proved. And at page 76 of transcript 5, they claimed that they didn't have to prove that Mr. Al-Hasan was a member of Ansar Deen, or that he made intentional contributions to the crimes and incidents in this case. So apparently, you can be part of a common criminal plan without being a member of it. And you can be responsible for crimes to which you've made no criminal contribution. And after lowering the bar for legal responsibility to below sea level, it would also seem that they want to prove facts without evidence. And we can see this from the evidential poverty of their description of Mr. Al-Hasan's role in these charged crimes. The prosecution's case is that Mr. Al-Hasan was a man of action, a key interpreter and enforcer who helped the organization to implement its common plan and its common purpose. That's transcript 5, page 67. But if that were the case, and the common plan involved a sufficient element of criminality, and not just Sharia law in general, then the prosecution should have been able to demonstrate that Mr. Al-Hasan's actions contributed in either an essential or substantial manner to the realization of the material elements of the charged crimes. So let's look at what Mr. Al-Hasan was supposed to have done as part of this common plan to enforce Sharia through criminal means. The prosecution has claimed that Mr. Al-Hasan apparently interfaced with civilians and mediated disputes between civilians at the request of civilians from Timbuktu. This hardly constitutes Mr. Al-Hasan enforcing religious beliefs through criminal means, and it certainly doesn't constitute a war crime or a crime against humanity. They have alleged that he received complaints submitted from civilians of Timbuktu, including complaints of serious crimes. Again, not something that demonstrates that Mr. Al-Hasan was enforcing religious beliefs through criminal means. If anything, it suggests that firstly, the civilian population accepted and approved of the Islamic police and the role played in Timbuktu. The prosecution's own witnesses also indicated that Mr. Al-Hasan only received complaints for the purposes of organizing them and then transmitting them to his superiors, Adama and Khalid. and I refer to the statement of P582, MLI-OTP-0070-0749 at page 0790. So he was someone who was good at file management. Hardly a sound basis for locking him up in Scheveningen. We then heard claims that Mr Al-Hasan signed reports. Again, hardly an essential or a criminal act. And under the system of Sharia law in Timbuktu, it was an act that had no bearing on the decisions and findings of the Islamic Tribunal. Mr Al-Hasan also allegedly went on patrols and passed on instructions concerning who was going on patrols. Again, something that would be expected from the police. Police patrol. It's what they do in administrations throughout the world without being locked up and separated from their family. If we go beyond these actions, these regular administrative actions, the prosecution case then enters the twilight zone of what Mr Al-Hasan could have done or might have done in an alternative reality based on completely different evidence which is not in the case file. For example, page 68 of transcript 5. The prosecution claimed that Mr Al-Hasan committed acts of persecution on the basis of race and gender. And in support of this very general claim, they then claimed that he carried out punishments of civilians during patrols for breaching rules. The problem is that there's no evidence in the case of Mr Al-Hasan punishing civilians during patrols. The prosecution relies on Mr Al-Hasan's statement that he went on patrols, but again, his evidence doesn't say what the prosecution wants it to say. Instead, he told the prosecution that it was the Emir who decided on issues concerning the petty tazirs, and only after a procedure was followed. That's MLI-OTP-0051-1184 at page 1210. The other witnesses who provided testimony in such matters, P582, P150, and P580, were also unable to give any examples of Mr Al-Hasan being involved in enforcing or inflicting such punishments. And I refer to paragraph 200 of our brief. Mr. President, Your Honours, you can't get from patrols to punishments. You can't get from A to Z on the basis of wishful thinking alone, rather than evidence. Potential witnesses to convince them to testify for the prosecution. I refer to MLI-0062-2996 at pages 3007 and 3011 to 3014. This witness was even so keen to help prosecution's investigations, he felt so close to them that he even mentioned during one interview that he wanted to work as an official part of the court one day, to which the prosecution responded, maybe one day. It's MLI-OTP-0067-1571 at pages 1609 to 1610.
Still 5 minutes.
Thank you very much, Mr. President. This person is not an objective and reliable witness, and his statements do not provide an objective and reliable foundation to confirm this case for trial. And that brings me to the next key witness, That's Mr. Al-Hasan himself, a person they interviewed 19 times while he was tortured on an ongoing basis, held outside the framework of the law in incommunicado detention. Now, the prosecution has claimed that since they didn't torture Mr. Al-Hasan, it doesn't matter. They've also tried to claim that he was in a position to give informed consent in these circumstances, that this was not a coercive environment. The admissibility of these statements will be an issue litigated before or at trial. But one would have thought that at the very least, the fact that these are written statements from a person who has not consented to testify orally at trial, one would think that it would warrant a degree of circumspection. But no. The prosecution has relied upon Mr. Al-Hasan's statements in 507 footnotes in the charges. And for 224 of these, he is the only source relied upon. And today, the prosecution repeatedly quoted from the poisonous fruits of this torture and coercive environment, and relied upon highly irrelevant and prejudicial sections to do so. Mr. President, Your Honours, the evidence in this case, it's not fit for trial at the ICC. If we ignore all the smoke and mirrors, if we examine carefully, clearly, and objectively Mr. Al-Hasan's actual conduct and what is established by credible evidence, not wishful thinking, and not the fantasies of particular witnesses, if we apply the lens of truth to Mr. Al-Hasan's conduct, a person from Timbuktu, living and surviving in Timbuktu along with everyone else, and this conduct doesn't amount to war crimes or crimes against humanity. And it doesn't justify a trial before the International Criminal Court, a body set up to try the most serious crimes of concern to the international community as a whole. So, Mr. President, Your Honours, instead of trawling for small fry, we ask you to release this sardine, the smallest alleged member of Ansardine, back into the sea. Thank you very much.
Merci beaucoup, Madame Taylor.
Thank you, Ms. Taylor. The defense almost exhausted its time, but I will still ask if Mr. Hassan wants to add something to what Ms. Taylor said. Do you want to take the floor, Mr. Hassan?
No, thank you, Your Honor.
Merci beaucoup.
Judge Kovacs, thank you very much.
Je vous remercie.
Thank you. This brings us to the end of this confirmation of charges hearing. The Chamber would like to thank the parties and participants, and specifically the interpreters, the court reporters, security officers, and registry representatives. The parties and participants will have the possibility to file written observations on the issues discussed, 30 pages maximums. These submissions should not contain procedural issues based on the schedule and the order. The prosecutor and the legal representatives have until 4 p.m. on the 24th of July 2019 to file their written submissions. The defense has a deadline of the 31st of July at 4 p.m. At the latest, the decision on the confirmation of charges for Mr. Hassan will be handed down latest 30th September 2019, according to the provisions in force. Court is adjourned.